Canada has moved quickly to enforce sweeping asylum restrictions, and the impact is already being felt across the country. Within days of the new law taking effect in late March 2026, immigration authorities began sending procedural fairness letters to thousands of refugee claimants, warning that their cases may no longer qualify for a full hearing. An estimated 30,000 individuals have been flagged as potentially ineligible under the new rules. These changes introduce two major barriers that reshape access to Canada's refugee system. The first is the one-year rule, which blocks claims filed more than 1 year after a person's first entry into Canada. The second targets people who cross the Canada-United States land border irregularly and waited more than 14 days to file a claim. Both rules apply retroactively to recent years, significantly expanding their reach. Many claimants are now facing a sudden and uncertain situation. Those affected by the one-year rule are given 21 days to respond with additional information, while others are being told to leave Canada and confirm their departure. Although these letters are not deportation orders, they warn that removal could follow if no action is taken. Immigration lawyers across the country report widespread panic and confusion. Many claimants had been living and working in Canada while waiting for their hearings, and now find themselves at risk of losing access to the independent tribunal that decides refugee cases. Instead, they are directed to a pre-removal risk assessment, a paper-based process handled by immigration officers. Legal experts have raised serious concerns about this alternative. Unlike a full hearing, the assessment does not allow claimants to present their case in person. Approval rates are significantly lower, with only a small percentage of applications being accepted compared to much higher success rates through the traditional hearing process. Lawyers argue that this limits fairness and increases the risk of errors. Additional concerns arise for claimants from countries where Canada has paused removals due to unsafe conditions. Even though Canada cannot return individuals to certain regions, some are still being told to leave, creating confusion and potential risk if they travel elsewhere. Experts are urging affected individuals not to leave Canada immediately based on these letters alone. Instead, they recommend seeking legal advice, gathering documentation, and responding within the given timeframe. Other legal options, including humanitarian applications, may still be available depending on individual circumstances. Looking ahead, these changes are expected to trigger a wave of legal challenges. Lawyers anticipate increased cases in federal court as claimants contest ineligibility decisions and raise constitutional concerns about access to a fair hearing. Human rights organizations have also expressed alarm, warning that the new system may weaken protections for vulnerable individuals. At the same time, Canada continues to face a large asylum backlog, with hundreds of thousands of claims still pending and processing times already stretching well beyond a year. The new rules aim to reduce pressure on the system, but they also introduce new uncertainty for those seeking protection. The situation is evolving rapidly, and its full impact on Canada's asylum system is still unfolding.